Hello, my name is Mercedes, and today we're going to be talking about judicial activism. So, what is judicial activism? Online, I found many different definitions. Most of them said the same thing, just in a different way. So, I compiled all that information and built one definition for us to go off of today. So, what is it? Judicial activism is a judicial philosophy that courts can and should go beyond the laws to consider alternative and more relevant judgments in a case. This implies that judges determine rulings based off their own beliefs, ethics, and morals, or their respective parties' beliefs. So next, I'm going to begin speaking about the pros and the cons of judicial activism. So, beginning with cons, the first drawback I found, which is also possibly the most dangerous when it comes to judicial activism, it is that judicial activism threatens to upset the balance between the three government branches. How, you may ask? It's because legislation is passed through Congress and the president. So if a judge makes a decision disregarding the law that was passed by both those branches, it threatens the validity of those in the other branches. It calls the other branch members' judgments into question, which causes distrust between the three branches. This also fosters distrust between the American people and their government. If the American people see a judge make a groundbreaking ruling on a case, it sparks something in the American people that says our laws are not written well, which means that Congress and the president isn't doing their job as far as legislation goes. So, the next con I found is when judges make decisions based off their personal or political beliefs instead of what the current law states, it could potentially endanger the result of fair justice. It only takes one bad judge to ruin what could be a beneficial practice. So let's say a judge has had an issue with a family member dying in a car accident. Now he has to go a few years later and oversee a case that involves that same instance. He or she may act more harshly on the defendant versus a different judge who doesn't have that personal connection to that crime, which isn't necessarily fair justice. Our whole justice system is based on fairness, so it's always a risk to do things like that and to practice that judicial activism in a case. So the third con I came up with is a judge is meant to be neutral ground between the defense and the prosecution. This kind of plays into my last point. It's difficult to claim neutrality when a judge acts on his or own accord instead of following what the law states exactly or what the law recommends. So in a court case, especially if it's being overseen by a judge and not a jury, the defense brings up evidence, the prosecution brings up evidence. They all show the evidence and the facts of the case to the judge. It's up to the judge at the end of the case to make up the decision whether or not the defendant is guilty or not guilty. If they're found guilty, then the judge has to determine what the sentence is going to be. And this is when judicial activism tends to come up more often than not, is when the ruling is. How harsh is the punishment going to be? So it can be a con because it may not be seen as fair justice. That judge may not be seen as being the neutral party that he or she is meant to be in the case. So moving on from drawbacks, I'm going to move into the benefits of judicial activism. So the first pro, possibly the most important, is that it keeps up with today's fast evolving modern justice beliefs and ethics. Our world today is constantly evolving. We're at a fast pace as far as activism goes and trying to right the wrongs of the past and all that good stuff. So it's helpful because some laws are old, written in ways that restrict modern justice. Therefore, acting on their personal view of the crime could outweigh the relevance of the punishment if it was given based solely on what the law states. I know it's dangerous to give someone power to create their own laws or write their own punishments. But there are many laws out there where the punishment does not fit the crime. Some are too lenient, while some are too harsh. There are people sitting in jail now for a crime they committed 20 years ago, but in today's world, it's completely legal. And people who get caught today don't go to jail at all. Maybe a ticket, maybe nothing. It takes significant amount of time to change laws and punishments. Judges are limited to exercising their power due to maximum and minimums on sentences for specific crimes that are committed. There's usually a law. Within laws, they have corresponding punishments that has this like a statutory minimum and a statutory maximum. Therefore, it's up to the judge to determine, like I mentioned earlier, how long or how harsh that punishment is going to be. So for an example, the minimum for committing the felony of burglary in Georgia is 1 year for the first offense, while the maximum for the first offense is 20 years. So after the jury finds a defendant guilty of burglary, it is up to the judge to administer that person's sentence, that person's punishment for their crime. Therefore, depending on the severity of the person who committed the crime, as well as the severity of the crime, the judge weighs the situation and comes up with a decision. This decision is often based on prior history of the defendant, as well as how many times they've offended and how many different crimes they've offended. They take the entire case into consideration when they make that decision. So a judge could be bold and sentence a person over the statutory maximum, but that usually results in appeals from the defendant, as well as some cases have actually been appealed also by the prosecution. So judicial activism can be dangerous, but it also can be super beneficial, especially in today's world. It really just comes down to what that judge thinks, and we as the people elect the president, and the president is the person who appoints the judges. So we kind of have to weigh in our opinion and know that one decision that we make as a people has a ripple effect. So if we support a president who supports a judge who is big on judicial activism, then we have to know that when we're going into electing that person to hold the office. Overall, judicial activism can be a good thing. It can be a bad thing. It's very controversial. Most people disagree with it. A lot of rule followers believe in going by the book, while other people, like revolutionists or activists, prefer to go beyond the lines and try to do the right thing regardless of what the book says. So that's my presentation and my cons and pros to judicial activism.
Hi, I'm Sophie, and I'm this week's article presenter for the debate. So this article will be discussing relations at the Supreme Court. So this will be a conversation on civics and civility, included discussion on whether the court is more likely to be a really good preschool or an arranged marriage with no possibility of divorce. A week after Justice Amy Coney Barrett chastised Justice Sonia Sotomayor for choosing to amplify disagreement with stridency in a Supreme Court decision on former President Donald J. Trump's eligibility to hold office, the two women appeared together on Tuesday to discuss civics and civility. They gave, for the most part, a familiar account of a collegial court whose members know how to disagree without being disagreeable. "We don't speak in a hot way at our conferences," Justice Barrett said, referring to the private meetings at which the justices discuss cases. "We don't raise our voices no matter how hot button the case is." Justice Sotomayor, who usually gives a sunny description of relations between the justices, registered a partial dissent. "Occasionally, someone might come close to saying something that could be viewed as hurtful," Justice Sotomayor said. "When that happens," she said, "a senior colleague will sometimes call the offending justice, suggesting an apology or other way of patching things up. Similar interactions can happen if a draft is too sharp," she said. "There is dialogue around that, an attempt to find a different expression," she said. Justice Sotomayor added, "So all of these things are ways to manage emotion without losing respect for one another and without losing an understanding that each of us is acting in good faith." Justice Barrett picked up the point. which may have resonated more strongly in the wake of her concurring opinion in last week's case. It questioned the tone of a joint opinion from Justices Sotomayor, Elena Kagan, and Brown-Jackson, saying they had needlessly turned up the national temperature. I'm glad that Justice Sotomayor brought up that sometimes we do need to apologize because we are human, Justice Barrett said. And so sometimes you say something that comes across maybe in a way that you didn't intend. The justices have norms to ensure collegially. She added, they speak in order of seniority at their conferences. Interruptions are not allowed and nobody speaks twice until everyone has spoken once. The justices often have lunch together and assign seats. As it happens, Justice Barrett said, she sits across from Justice Sotomayor. The norms of discussions at conference, she added, mean that you don't feel guilty about looking at someone across the lunch table. Eric Liu, the chief executive of Citizen University, who interviewed the two justices, said the court's norms sounded like the rules of a really good preschool. Another analogy Justice Barrett later said was that the justices were part of an arranged marriage with no possibility of divorce. Justice Sotomayor stressed that it is crucial to maintain good relations. I may not have Amy in this case, she said of a hypothetical one, but I certainly will need her tomorrow on something else. Justice Barrett said that the accommodations are sometimes possible. Our job is to say what we think the right answer is to the best of our ability, she said. So neither of us can compromise on that and the bottom line. But there's a lot that we can compromise how we write opinions. You know, you have the ability to write an opinion more broadly or more narrowly. She added, we all work very, very hard, down to like little word choices, oftentimes down to the smallest word choices to accommodate one another. Justice Sotomayor, 69, was appointed by President Barack Obama in 2009. Justice Barrett, 52, was appointed by President Donald J. Trump in 2020. The conversation took place at a forum on civics education at George Washington University. Civics education was a pet project of Justice Sandra Day O'Connor, who died last year. Justice Barrett recalled something Justice O'Connor had said. If you want to know what's going on in America, then you can look at our docket and you can see some of the battles that are being waged through litigation are often reflective of the battles that are being waged in the society at large. Justice Barrett said, the court strikes the right balance between openness and secrecy. We are simultaneously the most transparent branch, she said, adding that, you know exactly why we reached the decision that we did because we make that transparent. But then also we keep a great deal confidential, and I think that gives us the room to be able to deliberate and talk, she said. It is true that the court generally issues lengthy decisions in argued cases, but it often disposes of emergency applications on what critics call its shadow docket with no reasoning at all. Thank you.